Listen closely, because the information moving around today is making a lot of people emotional, excited, and honestly, nervous. And you do not want to make a single immigration decision based on a rumor. So here's what we're doing right now. We're breaking down the reported new US immigration law people are talking about today, what it claims to change, who could benefit, who should be cautious, and what you should do next, calmly, step by step, with your paperwork in order. Before you take action, make this your rule. Always confirm major changes through official sources like USCIS updates, DHS announcements, or the Federal Register. And if you ever feel unsure, talk to a qualified immigration attorney. That's how you protect your future, and that's how you avoid getting trapped by viral misinformation. If you want clear updates like this without the panic, hit subscribe right now, because these rules shift fast, and being early and being accurate matters. Now let's get into the first big change being discussed: employment-based green cards. The claim is that a streamlined processing system is being introduced specifically for employment-based applicants, and that USCIS would be required to move many employment-based green card cases within about 180 days. If you've been waiting in a backlog, especially if you're from countries that have faced the longest lines for years, this kind of timeline would feel like a breakthrough. It would mean less uncertainty, fewer endless months of cases pending, and a real sense that the system is finally being pushed to move. Another part being talked about is additional funding, more immigration officers, expanded infrastructure, and modernization, meaning more digitization, less paper bottlenecks, and fewer delays created by outdated processes. If you're on an H-1B, if you're stuck watching your priority date like it's a life sentence, the idea behind this change is simple: speed up adjudications, reduce the backlog pressure, and keep talent from getting trapped in limbo. There's also talk of expanding premium processing options beyond what people are used to, meaning that in certain situations, applicants could pay an additional fee for faster decisions, possibly in the 30 to 45-day range, depending on the category and what USCIS actually implements. And let me say this clearly: even if faster processing becomes available, it only helps you if your case is clean, complete, and ready. So start acting like processing could move quickly. Keep your employment letters updated. Keep your experience letters consistent. Keep your tax records organized. Keep your address history clean. And make sure your filings are accurate. That's how you take advantage of a faster system. If you want me to keep tracking what gets officially confirmed and what changes are actually implemented, subscribe now, because the difference between announced, proposed, and effective is everything in immigration. Now let's shift to something serious, and this part is aimed at current green card holders, especially those who spend long periods outside the United States. The discussion today includes stricter scrutiny for extended time abroad, especially if someone is living overseas while holding permanent resident status. The concept behind it is not new. Permanent residency is meant for people who truly reside in the US, not people who only visit to keep a card alive. But what's being claimed is that the enforcement standard could become tighter, and that absences over 6 months without proper documentation like a re-entry permit could trigger more review. If you've been outside the US for more than a year, you already know this can become risky because it can raise questions about abandonment of residence. Unless you have strong proof of ties and a clear story, what's being emphasized in the reports is that the government wants to see real connections, property, family, ongoing employment, a consistent US address, tax filing history, and evidence that the US is your true home base. There's also a claim floating around about a yearly online confirmation of residence requirement, something described as quick and simple, but important, because missing it could flag a file for review. Whether that specific form requirement becomes real or not, the message you should take is real. Stay organized, stay compliant, and keep your records consistent. If you live in the US full-time, work here, pay taxes, and build your life here, this should not be something that scares you. But if you're a green card holder spending most of your time abroad, you need to get serious, because the risk is not just paperwork, it's your status. And if you want practical, no drama reminders on what to keep, what to file, and what patterns trigger issues, subscribe, because these details save people from painful surprises. Now let's talk about a part that's getting a lot of attention: healthcare workers. The reports claim a fast-track pathway to green cards for certain healthcare professionals, nurses, doctors, medical assistants, therapists, and even home care aides. The reasoning behind it is obvious. The US has been dealing with major healthcare staffing shortages, and the idea of keeping trained professionals here is a powerful policy goal. What's being claimed is that certain healthcare workers on temporary work visas could apply with fewer delays, possibly with reduced labor certification barriers, and that a separate visa quota could be set aside specifically for healthcare, with a number being discussed as an additional 25,000 green cards per year beyond the usual caps. If something like that becomes officially implemented, it could mean faster approvals, less competition in those lanes, and more stability for the people doing some of the most essential work in the country. The discussion also includes stronger worker protections, preventing exploitation, meaning employers would have less power to threaten a worker's immigration situation to force unfair conditions. If you are in healthcare, take this as your signal to get ready. Gather your licensing proof, credential evaluations, offer letters, pay stubs, job descriptions, and immigration history documents. If the window opens, prepared applicants move first. And yes, if you're in healthcare and you want constant, accurate updates without getting misled, subscribe, because this category is moving and it can change lives. Now we need to address the part that causes the most confusion online: public charge. The reports claim a strengthened public charge approach, meaning USCIS would look more closely at financial self-sufficiency, and that extended use of certain public benefits could add scrutiny in green card applications or certain immigration decisions. Let's keep this calm and clear. First, people should never panic and stop caring for their health or their family out of fear. Second, what matters in immigration is the full picture: your employment, income, savings, household size, long-term stability, and the specific rules that apply to your specific case type at that time. The claim being repeated is that if someone has relied on certain benefits for over 12 months within the past 3 years, it could trigger closer review. Even if that becomes part of a policy framework, it still would not automatically mean everyone gets denied. It would mean you need stronger documentation and a stronger story. So the practical move is this: strengthen your file. Keep proof of work, keep proof of income, keep your tax returns, show consistent effort, show stability, and if you're preparing to apply, build your financial readiness. Even part-time work can help show responsibility, having savings helps, having health insurance can help, and showing that you contribute can matter. This is not about shaming people who struggle. It's about how the system measures risk, fairly or unfairly. That's how it works. If you want me to keep explaining complicated rules in plain English, without fear tactics, subscribe, because most people don't lose their case because they're ineligible. They lose because they misunderstand the rules. Now to the part that brings a lot of hope: dreamers. The reports today are claiming a permanent legal pathway for certain dreamers, including people who have lived in the US since childhood and who meet criteria like continuous residence, clean background, and education or military service. The emotional weight of this topic is real because temporary protections can feel like living on a timer, and families have been waiting for stability for years. What's being discussed is a move from temporary, renewal-based protection into a pathway that could lead to permanent residence and eventually a stable life without fear of the next renewal deadline. The claims include prioritizing processing with an approval goal within around 12 months, and also some assistance options to reduce fee barriers for applicants who have faced financial obstacles. Whether every detail is implemented exactly as described or not, the takeaway is clear. If you or someone you love might qualify under any dreamer-related pathway, you should start building your evidence file now. Keep school records, medical records if relevant, proof of address history, proof of continuous presence, employment records, tax filings, and any current approvals or renewals. Do not wait until a deadline appears. Prepared files move faster and they move safer. Now let's move into entrepreneurs, innovators, and job creators. The reports claim a new startup-focused pathway, allowing certain foreign founders to seek green cards if they can prove real economic contribution, real job creation, and real investment support. The example being repeated is a founder who raised at least $250,000 from qualified investors, created at least 5 full-time U.S. jobs, and could potentially pursue a green card without a traditional employer sponsor. If you're a founder, here's what you should understand. Immigration options for entrepreneurs have always been complicated, and when new pathways open, the winners are the people with clean business records. So, act like an auditor is reading your story. Keep your incorporation documents clean. Keep your cap table accurate. Keep investor agreements documented. Keep bank records organized. Keep payroll records clear. Keep job descriptions real. And keep tax filings consistent. If you're serious about using a business to support your immigration journey, you need compliance, clarity, and credible numbers. There's also discussion of updates to the EB-5 investor route, with a claim about a reduced investment threshold in certain rural or high unemployment areas, and stronger anti-fraud protections. If you're considering EB-5, the practical advice is always the same. Never rush, never trust hype, do deep due diligence, and get independent legal guidance. Your money and your status are both on the line. Now we get to the part being described as affecting everyone, biometrics and modernization. The reports claim that starting about 6 months from today, green card holders could face a mandatory biometric renewal process every 10 years, including fingerprints, updated photos, and in some versions of the claim, even enhanced biometric measures. The reasoning being presented is modernization, fraud prevention, identity protection, and updated records. Alongside that, there's talk of a secure digital green card component, meaning a physical card plus a verified digital version accessible through an official system. If modernization expands, the practical thing is not to fear it, it's to be organized. Keep track of renewal timelines, respond to USCIS notices quickly, show up to biometrics appointments on time, and never ignore official mail. Most status problems happen when people miss a notice, miss an appointment, or delay a response. So if new steps are added, treat them like a routine checklist, not a crisis. Here's your next step, and I want you to take it seriously. Do not forward viral claims as confirmed law until you verify them. Do not let fear push you into rushed filings. Do not let excitement push you into paying someone who promises shortcuts. If you are employment-based, prepare a decision-ready file. If you are a green card holder who travels a lot, strengthen your U.S. ties and plan your time carefully. If you are in healthcare, get your credentials and records organized. If you are concerned about public charge, focus on stability and documentation, and get case-specific legal guidance. If you are a dreamer, start building your proof file now. If you are an entrepreneur, build a business record that can survive scrutiny. And if you want me to keep bringing you updates in a way that's actually useful and not just loud, subscribe right now, because consistency matters, and the people who stay informed, stay ready, and stay accurate are the people who protect their future. Now drop a comment and tell me where you're watching from and which category you're in. Green card holder, employment-based applicant, healthcare worker, dreamer, or entrepreneur, and what your biggest concern is. Travel rules, processing delays, public charge, or renewals. I read the comments, and I build the next breakdown around what you actually need. And again, subscribe. Because one verified update at the right time can save you months, sometimes years, of confusion and stress.